Chat's calling, grab your mug and settle in. We're unwrapping cases, rumors, filings, all the mess these folks get in. Lights are twinkling, drama sprinkling, same chaos, extra shine. It's a holiday hangout, so come on in and hit go live. Cozy blanket, court romantic, somehow both at once again. Every dot drop feels like Christmas when the tea comes rolling in. Chats laughing, mods are clapping, trying not to lose the plot. But if the filings go sideways, hey, at least the coat goes hard. Wrap the week up like a present, tie a bow on all the hype. If the judge says something spicy, we'll pretend that it was nice. From the chaos to the comfort, from the hearings to the cheer. Pull up close, the stream is starting, it's our weird little time of year. It's a baker Christmas dream where the tea is warm and the kisses screen, lights are bright. Chats in the zone, hit that play or not alone. It's a baker Christmas dream where the tea is warm and the kisses screen, lights are bright. Chats in the zone, hit that play or not alone.
Good evening, everyone, or good afternoon to you in Americas, and welcome to a presentation from, I don't think we're going to get much from the court today because Cosi El Cosio, the man, the myth, the absolute sloth, just filed a memorandum in opposition to Attorney Bettero's affidavit in support of motions to disqualify, etc. 3 hours before they are having a court meeting, 2 weeks after he was supposed to have it filed. They should, but they won't hold his ass in contempt. I'm going to read it. I'm dyslexic. This is my third language. I was sent a screenshot of one page, and the first thing I found was a mistake. Again, I'm dyslexic. This is my third language. How can a special prosector who is paid I don't know how much to have this case be this bad at his job? This should be something a law clerk could file for him. And I want you to do your homework. Hey, Restless Mom, how are you doing? Been a while. Everyone, take your pen and pencil. There will be homework because I will ask you at the end who it sounds like who wrote this piece of Carabiola. This is really bad. This is, as Marissa says, it looks like a kindergartner wrote it. So, too much? Yeah, let's just start with Lindsay Kearney is a faithful single mother. That's in there. Lindsay Kearney, who snuck into a famous local journalist, streamers, DMs to get finger banged at McDermott or whatever that nightclub, restaurant, whatever it is, because sneaking into someone's DMs saying, "Hey, daddy," is because you're really, really faithful to your husband, boyfriend, baby daddy that you keep sending to prison. My scale of greatest women in history You have Mother Teresa, the Virgin Mary, and Lindsay, the faithful housewife Kearney. No, it's set to start at 2:15. I do have the Zoom meeting set up, so when and if we'll go to it. Looks like me, the Commonwealth is just keeping Aidan on probation until they can find a way to make him violate it. This is so obvious what they're doing. It seems to me that these a-holes should null pros all of this so they don't lose faith by saying, well, we could have prosecuted it, but we chosen not to, and just get it out of here. Because let's just get to it. This is redonkulous in the 11th degree. The defendant, Aidan Kearney, has filed an affidavit in support of motions from Betterow. As with a previous Betterow affidavit, the motions are phantoms, and there is no memorandum of law accompanying the non-existent motions. There is a memorandum of law accompanying today. That's been filed yesterday, but I haven't seen what's in it. Restless Mom says, I have missed you. I was too busy soaking in the Mexico sun. Still love you mucho. Gracias. I hope you had a wonderful vacation and that all of Mexico was wonderful. My brother's been to Mexico a couple of times, and he says it's a great place. Just make sure you don't go the bad places. And go Ducks. The Commonwealth infers that the affidavit in support is intended to serve all three functions, and assuming arguendo that this court consents to accept it as such, the Commonwealth offers the following response. The defendant first asked this court to preclude the Norfolk County's DA's office, henceforth NDA, from appointing another special prosector to docket number, that's the 2482 case, the 2024 case, due to its irreconcilable conflict with witness Lindsay Kearney. That request is moot as the district attorney's office has since entered a null prosequi on that case. The defendants remain free, of course, to contest the validity of that null pro by litigating whether the NDA's alleged inconceivable conflict disable it from taking that action and insisting on the revival of that indictment. But so far, he has shown no sign of doing so. Next, the defendant asked this court to disqualify Special Prosector Cosgrove from docket number 2382, the 2023 case, because of his alleged irreconcilable, Jesus Christ, stop using long words, conflict with Ms. Kearney. Much has been said in previous filings with respect to Ms. Kearney, and she herself, with prior leave of this court, has filed a number of pro se documents. All of that pays examination, but the Commonwealth offers a brief background summary. Kearney is a single mother and a faithful, perhaps even a compulsive follower of online postings on such outlets as YouTube, Twitter, and Facebook. In this context, she viewed some of the defendant's online postings related to then pending Karen Read case, sent him a laudatory message. I think he could just have said, snuck into his DMs to try and get the Dominator. Ordered one of his free Karen Read t-shirts, then sent him a photo of herself wearing that shirt. Correspondence ensued, and not long thereafter, an intimate physical relationship, bolstered by Kearney's bragging about his inside knowledge of the Karen Read case. So, if we believe Cosgrove, moist o'clock happens for Lindsay if you say, oh, I have insights on Karen Read. I know some of you ladies are a little bit freaky, and this is a no shame on kink zones. But if your dirty talk is, Karen Read is not guilty, then maybe then maybe, I'm just, yeah. Um, we might, we might judge you a little bit on this platform. His inside knowledge of Karen Reed case, dinners and drinks. No dinners and drinks was had with Karen Reed, according to Aidan. Maybe it's dinners and drink with Kearney. Use of the internet to exchange text, including those with explicit sexual content. Oh my God. Oh my God. My pearls be clutched. A newly semi-divorced, their relationship probably had ended at that point. Guy had a pretty girl reach out to him and say, hey daddy. Oh my God. He wrote her back and said, can I see your bum? Oh my God. Oh my God. I need to clutch all the pearls. And the defendant sometimes practice of videoing their sexual escapades with his cell phone camera. Oh my God. At some point, the Kearney relationship began to founder, and at about the same time, Kearney began to have doubts about the innocence of Karen Reed. No, she just wanted to be in opposition to Aidan because she was mad that the Dominator was not hers anymore. Whether on her own initiative or, as the defendant posits, the influence of other denizens of the online community, such as Catherine Peters. Isn't her name Catherine Peter? Is it Peters? I always get it wrong. Kearney contacted Tully, who was leading the NDA investigation into intimidation of witnesses in the Reed case by the defendant. Tully interviewed Kearney. The Commonwealth had already developed another witness, Natalie the German, who could attest to communications between Karen Reed and the defendant during the months of April and June 23. Kearney's information confirmed such contacts after that date based on what the defendant had told her. Yeah, she's Peter, no S. So that's the first mistake. Again, I'm dyslexic, third language. I want all of you to take notes and tell me later what is wrong. Yes, clutch all them pearls. Imagine two consenting adults playing online, and maybe two consenting adults having a little bit of brown chicken, brown cow. I have never ever heard of such a thing, but I'm a 27-year-old virgin, so where should I know about it from? Tom, I, I think he has paralegals from Crust and Twist Law School because it's horrible. Oh, conveniently, Lindsay isn't a witness anymore from the Commonwealth. Well, she is for the defense now. Tully reported on the interview to Special Prosecutor Kenneth Mello, who had Kearney served with a grand jury subpoena. Kearney had apparently hoped not to have to testify and began to panic upon receipt of the subpoena. She telephoned the defendant and informed him that she had been subpoenaed and attempted to minimize her role in the matter. After some discussion, the two agreed to meet at Kearney's apartment building, where Kearney demanded to examine Kearney's cell phone and took notes of some of its contents. He urged Kearney to delete various items from her phone, representing that he had checked with his attorney, Bradel, and that there was no preservation order in effect, that there was no problem in doing so. At one point in the early hours of the morning, Kearney excused herself to use the bathroom and telephoned Special Prosecutor Mello, awakening him. Mello had difficulty understanding what Kearney was saying, beyond understanding that she was fearful, but effectively arranged to transfer the call to Tully. This is a different story than he told in his last filing. In the last filing, it was Tully who couldn't understand him. So I'm just saying, I know you're late and your homework was eaten by your dog and stuff like that, but the last story it was Tully who couldn't understand, but now Mello can't understand her. A brief exchange of messages followed, then Kearney returned to the defendant. Further conversation ensued, as did other events. Brown chicken, brown cow. After speaking with Kearney the following day, Christmas Eve, the real Christmas, not the American one, and learning that she had not reported the incident to the local police, Tully did so. The defendant's arrest soon followed, resulting in revocation of previously imposed bail. Kearney was granted a 209 restraining order. The defense's theory, as discussed in the Commonwealth's memorandum in opposition to Attorney Betterow's affidavit in support of motion and associated submissions, henceforth mem up, is that Krusty, Lindsay Kearney, and Mr. Mello, Tully, and possible other diabolically plotted to have Mr. Kearney's bail revoked by luring him into intimidating Miss Kearney after they made her what Mr. Betterow described as a witness, taking care to put the term in scare quotes. You put motion in scare quotes all the time, you idiot. Subsequently, the defendant went to the Medfield police and alleged that Kearney had wiretapped him by recording a sexual encounter without his consent, using a home security camera. As a result, Kearney was interviewed by the Medfield police, and in the course of that interview, Medfield police was informed of a sexual encounter on October 14th, which Kearney had recorded. Per Kearney, he sent her a copy of the recording the following day. The question arose as to whether Kearney on that occasion lacked the capacity to consent and thus was raped by Kearney. But Kearney initially did not want to proceed with charges. The police subsequently met with Mr. Kearney and, among other things, advised him that they had a copy of his video of October 14th. Why are you putting this in here? These charges was never brought. Why are you putting it in here if it's not just to me, this seems like, oh, we're going to give all the idiots on the other side something to talk about. Let's talk about all the rape charges against Aidan again. That never, ever was rape charges. This hasn't. They said there's nothing there. You were drunk, but you were participating. No way in any way you claimed what happened. Why are you putting this in the motion? This is not substantial to the motion to recuse. No, this is it's a background story that has nothing to do with the charges against Aidan. This is pure character assassination on Aidan Kearney to allege that he might have raped her, but your own fucking officers didn't do anything about it. My Dutch Shepherd and Belgian Mal both understand 3 languages: English, German, Dutch, English, German, and French. Well, I understand 2 of those. What does this have to do with the motion to recuse? Nothing. Nothing other than just to show how bad Aidan is. I'm reading Betterow's response. Oh, is that out there now? My mods haven't gotten that one. According to Cartoony, on April 13th, Kearney publicly announced on YouTube that the Medfield police was investigating him for rape, calling it a lie. This was the first public mention of the allegation initiated by Kearney himself. Defendants answer and counterclaim hereafter. A and C, Kearney v. Kearney, Worcester, sub 2585, I don't know. Kearney launched an online campaign of vilification against Kearney. She was a fake victim, an unfit mother, a drug user who supposedly fell asleep bagging items at the grocery store. What does this have to do with Cossie G? You must recuse yourself because you talked to this woman. That Aidan has said she's a fake victim. Your own police officers said no grape. So she is a fake victim. If she claims victimhood, in a rape that never happened? Is she a real victim? An unfit mother. Can someone think of why Aidan might potentially at some point have claimed that she was an unfit mother? It's not like there's any court documents out there that could indicate a small little bit of a problem with her motherhood at sometimes, and a drug user. Well, going back to the unfit motherhood, wasn't there something about her parents wanting her kids so she could go get help? Yes. Now Cosgrove is doing exactly what he claims Aidan did. He is just going to make her a bad witness. It's so absolutely cray-cray. I'm sorry, but it is. The judge doesn't have to allow it, and hopefully he won't. He will. It's Massachusetts. He's going to say, well, you broke all the deadlines and it is absolute bullshit, but I'll allow it. She supposedly confined one child to sleeping in a closet and was described in Kearney's posting as closet baby. Kearney was said to be in jeopardy of being indicted. Why is closet baby all of a sudden in these motions? Kearney was said to be in jeopardy of being indicted. On and on the attacks went, with Kearney's devoted online acolytes, that's all of you weirdos, gleefully piling on, picking up the cry of fake victim, photographing Kearney in various locations. You did that? You bums. Sending accusatory messages to her children's school and texting her with obscenities, accusations, and threats. One among Kearney's enthusiastic collaborators in the campaign of vilification against Kearney was Jason Broyles, who initially appeared online under the pseudonym Haley Walbrick. What does Jason Broyles have to do with Cossie G's motion to dismiss? Cossie, put on the Velcros, let Mrs. Cossie be in the basement, and make this make sense. Broyles serially posted derogatory material about Kearney, interspersed with exhortations to her to prevent him from continuing to do so by telling the truth, publicly adopting Kearney's version of events. And repudiate her own statements. Eventually, Kearney responded to the verbal assaults against her on her social media account, denouncing the defendant as a rapist and describing him with other derogatory terms. On January 8, represented by counsel, Kearney filed suit in Worcester Superior Court, alleging slander, libel, and intentional infliction of emotional distress, and seeking damages and injunctive relief. After an unsuccessful motion to dismiss, Kearney, proceeding pro se, filed an answer and counterclaim on September 8. Again, Cossie G. Y. In the course of litigating a Dedham District Court case involving an alleged violation of a 209 order granted Kearney against the defendant, Cosgrove had provided as discovery the Medfield police report on October 14th incident to attorney Bradle. Bradle, or someone acting on his behalf, gave the report to Kearney. Kearney provided it to Broyles. On August 8, Broyles posted Kearney Files Part 3, including the unredacted confidential police report of Kearney's sexual assault allegations. In A&C, in addition to answering Kearney's allegations, Kearney attempted to implead Cosgrove Tully and the Medfield police officer. The factual basis of all her allegation against Cosgrove is that his turning over the report to the defense violated GLC 41, paragraph 97D. As a result of Kearney's filing, ANC Cosgrove filed a motion to withdraw from 2482, believing that a conflict existed between defending, should it become necessary, against Kearney's ANC and prosecuting an indictment where she was the alleged victim and primary witness. That motion was allowed without argument and without objection. The defense now seeks to leverage that withdrawal to force Cosgrove's removal from the present case. Why is Cosgrove? In which Kearney is not alleged to be the victim and is not a necessary witness for the Commonwealth. All of the named witnesses in the present case are either witnesses in the Karen Reid case or relative of witnesses. Kearney is not a precipitant witness with respect to any of the counts in the present case. To the extent she would be of any use to the Commonwealth, to the extent she would be of any use to the Commonwealth at all on these counts, it would be to testify based on her conversations with Kearney as to Kearney's relationship with Karen Reid, which goes to his motive for the intimidation of witnesses. Kearney would be expected to testify that during her relationship with Kearney, Karen Reid would come up a lot in conversations, so hearsay. Further, that he told her he communicated with her on a daily basis, and that with much of his reporting on the Reid case, he would have to run everything by her, that she had a lot of control or almost complete control over anything that he posted. He was not allowed to make any sort of comment about her case without first consulting her and getting her prior approval. Grand jury minutes from February 1st. If the Commonwealth wishes to introduce such information, it can do so through other means, including the contents of two of Kearney's cell phones seized pursuant to warrant, which show extensive communications between the defendant and Reid, as well as communications with some of Reid's attorneys. In short, there is no need whatsoever for the Commonwealth to call Kearney and no need for prosecution to, as to the defense posits, defend the credibility of a prosecution witness who has sued him for his alleged misconduct. The defendant argues, however, that it will call Kearney, who has apparently now, for whatever reason, maybe because she wanted the truth out there, made a complete U-turn and taken a Kearney-like position that Special Prosecutor Mello and Tully conspired with Krusty to use her, and now he spells her name correctly, her last name, to use her and sacrifice her as a pawn to take down Kearney, and that therefore Cosgrove should be disqualified on the ostensible grounds that he is somehow ethically conflicted from cross-examining her. A prosecutor is not required to uniformly buttress or implicitly vouch for the entirety of the testimony of a witness he calls. The modern view and the law in Massachusetts is that the suspect, to a few limitations, any party, including the party that called the witness, may attack her credibility. So you're going to attack Krusty on the stand? Whatever purchase this argument may have for the now dismissed complaints where Kearney was herself the alleged victim, there is no basis for dragging the entirety of that dispute into the present indictment, where Kearney accounts for virtually zero of the Commonwealth's evidence, either in its collection or its preservation. The expected evidence will primarily be the testimony of the alleged victims and Kearney's own video online statements. A side trip into whether the Commonwealth did or did not probably conduct the Kearney investigation is irrelevant, not probative, and highly prejudicial, threatening to turn this trial into a circus. Cossie, you missing every deadline has turned it into a circus. You are the three-ring circus clown. The Commonwealth will vigorously oppose the attempt to divert the jury down this lengthy and winding side road to nowhere but confusion. Should this court, after hearing, permit the proposed Kearney defense testimony to the extent that Ms. Kearney's U-turn contradicts previous statements made under oath, she may expose herself to legal peril, and the court should ensure that before she proceeds, she has appointed counsel. Threats against a potential witness. This is not a threat because it's done by the state, but this is written so Kearney is afraid to testify. According to Massachusetts' absolutely insane witness intimidation laws, Mr. Cosgrove should now be facing charges for witness intimidation, because this is a veiled, it's a hidden threat that, hey, if you piss just a little bit beside the pot, we will prosecute you for perjury. Oh, by the way, I forgot to. Marissa, can you or Jess, can you share the link to Aidan's fund? Oh, there it is. Thank you. As always, when we are covering this, if you want to help Aidan and his defense fund, it's the link at the top of the chat. Thank you, Jemima. I just remembered it. Clearly, her interests are far from synonymous with Mr. Kearney's. Finally, the Commonwealth notes that to the extent any disability arises from Mr. Kearney's ANC, whenever, if at all, the counterclaim against Cosgrove goes before the Middlesex Court, it is unlikely to survive a motion to dismiss or for judgment on the pleadings. Its entire basis is an act by a prosecutor in the course of his duties, and whether or not Cosgrove was correct in concluding that providing a copy of the police report to the defense was proper Rule 14 discovery, no liability should attach. The defendant's third and final request is perhaps his most brazen. He asked this court to disqualify Cosgrove from an ongoing investigation of Karen Reed and Mr. Kearney for conspiracy to commit witness intimidation, the 2005 investigation. How can he be this dumb? Again, he's 4 weeks late. This is filed just before they're going to court today. And he can't even keep, he has the 2023 and the 2025 cases left, and he makes it wrong. Thank you, KDP, for liking the classes. I can read better now, and Marissa, don't yell at me. He can't know that there's no guarantee it gets dismissed. No, he don't know anything, but he seems really up for it. He wrote it in a rush for some reason. Well, probably because he went online and saw all of us talking heads saying, where the hell is his answer to the motion to dismiss? Again, based on alleged... Oh, are we starting? Melanie, you have to mute your... Melanie, for Christ's sake.
Remain on mute, and if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, Mr. Cosgrove.
Go ahead, Tim.
Mr. Bradley, you're muted.
Sorry, Your Honor. Hello, Tim Bradle for Mr. Kearney, Your Honor.
Good afternoon, Mr. Bradle.
And Mark Betterow for Mr. Kearney. Good afternoon, Your Honor.
Good afternoon, Mr. Betterow. Good afternoon, Mr. Kearney. Okay, folks, first time meeting, so let's have a brief before we get into the substance. I've noted from the docket on this case that there were already a couple of judges who recused themselves given past dealings. So I want to deal with that issue right up front and get that out of the way. I'll start with the parties first. I've never dealt with you, Ms. Betterow. This is the first time I'm meeting, so I don't think there's any reason for me to engage in any analysis under Rule 211 with regard to disabling prejudice. So I think we're clear on that issue.
We're good, Your Honor.
Excellent. I'm glad to hear that. With regard to Mr. Bradle, Mr. Bradle and I have known each other for more than 30 years. We tried cases against each other when he was with the Suffolk County District Attorney's Office, at least a couple, probably more. I don't remember, but there were at least one significant case against each other. During the time that he was a member of the defense bar and I was a member of the defense bar, We handled cases, co-defendants, although cases went to trial. We certainly had a number of cases in which we represented co-defendants, at least through the motion stage. Outside court, we had a cordial, friendly, and cooperative relationship as members of the defense bar, but we did not socialize anywhere outside a legal setting. So, given our dealings, I'm certainly satisfied that I don't suffer from any disabling prejudice with regard to Mr. Bradel. With regard to Mr. Cosgrove, when he was just Judge Cosgrove, I did appear in front of him a number of times. I really don't know how many times, but probably better than 25 or 30 times, I'd guess, as he sat in the various counties. I don't recall that he ever presided over trial that I did, but I know for certain that I did a number of motions to suppress and motions to dismiss with then Judge Cosgrove. There was nothing out of the ordinary relationship. It was purely a relationship between counsel and the judge at that time. We've never had any social contact except for in legal settings, and they're extremely minimal. Given that I took the seat that then Judge Cosgrove vacated, we were never colleagues on the Superior Court and never had any interaction on that level. And as I said earlier, we've never had any social interaction outside a few minimal contacts in legal settings. So I'm fairly comfortable in reaching the conclusion that I suffer from no disabling prejudice due to past appearances before, and certainly never did work with then Judge Cosgrove. With regard to the parties in the case, I've gone through the pleadings as much as I can. I've looked at the indictments. I've noted the names that seem to come up over and over. I'm familiar with none of these people. I've never met any of the civilians or interacted with them directly or indirectly who are involved in this case. As to members of law enforcement who are involved in the case, some of those names I have encountered, members of the state police, as well as members of the Boston police. I would add to that any dealings I had with them would have been as a criminal defense attorney, probably mostly seeking to undercut their credibility, but never had any personal dealings with them outside a courtroom. Certainly no social dealings with them. So I'm fairly comfortable in saying that I suffer from no disabling prejudice with regard to any of the parties who I've seen listed in the papers. The final issue, it is public knowledge that I grew up in Canton in the 60s and 70s and part of the 80s. I'm considerably older than all of the people involved in this case, so I didn't go to school with any of them, nor did any of the names, as I said, ring a bell for me. I lived in Canton, graduated from Canton High School in the early 80s, moved out for college, lived there intermittently through college and law school, and left there for the final time in, I want to say 1990, to the best of my memory. May have used it as a mailing address after that as I cycled through some post-college apartments, but have not lived there full-time since the early 80s and have not lived there at all since no later than 1990. I don't have any contact with the town in particular, nor do I have a prejudice for it, for or against any issues that might happen in that town, nor special knowledge thereof. So I'm comfortable in finding that I have no disabling prejudice as to my past associations in the 60s and 70s and early 80s with the town of Canton. So that being said, I'll go around the table and see if anybody has any problem with that, beginning with the defense. Any issue at this point with regard to disabling prejudice under 211?
No, Your Honor, and I agree with everything you said, and I appreciate the comprehensive rundown of everything.
Attorney Cosgrove.
I thank Your Honor for your thorough summary. Your recollection of our personal associations exactly coincides with my own. Having listened to your explanation of your associations with Attorney Bradel and your knowledge or lack of knowledge of the witnesses that may be involved in this case, I have no objection to Your Honor sitting in this case.
Okay, excellent. All right, so obviously I'm in Brockton. You guys are at different places. I'll give you my schedule going forward. I'm assigned to Suffolk Superior Court. The first 6 months of the year, I'll be sitting in room 1008, which is a civil session. The second 6 months of the year, I'll be in room 808, which is a criminal session. I think at least for now, we'll work this out as we go forward, have a greater clarity as to how we can handle it. At least for now, for the next set of motions, which we need to get to, what we'll do is we'll do those in person in Suffolk Superior Court. What room that's going to be in, I don't know yet. The way Suffolk runs things, their civil clerks don't sit on criminal matters. There are two separate clerks' offices in Suffolk. They're very distinct in what they do. So either I'll bring the matter into 808 where there is a criminal clerk, or will perhaps be specially assigned to another courtroom. Sometimes courtroom 1309 is used as overflows. I don't know where we're going to be yet, but I can tell you that the next set of hearings will be in person in Suffolk Superior Court. So let's move on down the agenda. I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now. So, assuming, well, let me just say this. If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion, or allowed it in some modified form, to set up a taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team, and then at that point, the Commonwealth would get the information as approved by the court to go through it, and assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate, well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this. As I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download of 2 phones, which is in the Commonwealth's possession and which has been turned over to the defense. And there are other electronic devices which were seized as a result of the search, and that's what is subject to the ongoing taint team here.
And there's no conspiracy charge between Reed and Kearney in this case, correct?
No.
So presumably any evidence we have with regard to Kearney is going to come off his own phone, I take it.
Well, that's the situation now. I can't speak to what might be discovered in the process of the search. The conspiracy that's alleged in the search warrant is conspiracy to intimidate a witness. The charges against Mr. Kearney here include intimidation of a witness. So it could be relevant, although obviously, no. If any conspiracy indictment resulted against Mr. Kearney, it could not be tried with the indictments here absent his consent.
Okay. So, Mr. Bradle, briefly, anything to add to that in terms of just what procedurally would have? I don't want to get into the substance of that issue. We
Sure.
can deal with it later if we need to. But procedurally, you sort of think that's the way it would go?
Judge, we are interested in dealing with the disqualification motion first. Attorney Bettero filed a very comprehensive motion to disqualify Mr. Cosgrove. He's being sued by.
I'm going to come to that, Mr. Bradle.
Yeah.
Just want to make sure we understand the impact of Judge Krupp's.
Sure.
Judge, if I may, that, and I don't want to merge the motions, I understand what the court is doing, but that disqualification motion also includes the investigation involving Miss Reed's cell phones, because it is virtually the identical conduct and the identical facts that are from the 2023 indictments. And again, without merging too much of this now, there is a disqualification motion on the indictments before Your Honor now, as well as the investigation that Mr. Cosgrove is doing, because the same witness who is at issue in the disqualification was a primary or one of the primary sources that led to the warrant to go after Miss Reed's phones. So they are kind of intertwined. And if Mr. Cosgrove is saying, as he seems to be suggesting, that he can't predict the future in the event that he were able to search the phones, but if evidence were to be discovered and lead to a conspiracy indictment against Mr. Kearney, that implicates the disqualification issue. At this time, I'm unaware that Miss Reed has joined that motion, so I don't want to speak for what her counsel would advise. But to the extent Mr. Kearney is involved in anything to do with what we're calling the open investigation involving Miss Reed's cell phones, we think that the disqualification as it relates to Mr. Kearney needs to be dealt with in the first instance.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did, up until the point where
I'll get to that. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come. And what Attorney Cosgrove chooses to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later. And it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
All right. So how soon would we be ready to deal with the issue of disqualification?
Judge, I just wanted to throw out some dates if I could. January 12, 13, or 15 is what we're proposing.
Okay. Does that work for you, Attorney Cosgrove?
No, I'm out of the country on all of those dates.
Okay. How does now, Mr. Bradley, you've got some other business that's going to happen up in Essex County. You're scheduled for trial up there?
That's February 9th, Your Honor. That's correct.
And how soon before that are you going to?
Your Honor, I could give me a moment.
Hold on, Attorney Cosgrove. Mr. Bradle, how soon before you become unavailable due to that trial?
Judge, I'm pretty flexible. I really don't want to delay the disqualification too much. I mean, unless Attorney Betterow has a different view, I'm thinking, can we do it a little sooner then?
No, I want to wait till I get to Suffolk.
Okay. Oh, I understand. Maybe is it should we do maybe the third week in January?
Let's see what Attorney Cosgrove has to say. What's good for you, Attorney Cosgrove?
That's fine.
Let's pick a Friday, late January.
That's the 23rd.
Attorney Cosgrove,
I can do the 23rd.
Mr. Bradle.
Yes. Thank you, Your Honor.
All right, so we're going to mark that up for January 23rd. I'll be in touch with regard to time and place. I need to talk to Suffolk to see where they can accommodate me. I'll know that certainly by early January, what courtroom we're going to be in and what time. My inclination probably would be maybe a noon or a 2 o'clock hearing. I don't expect it's not going to be non-evidentiary, I take it, correct?
Correct.
Initially, at least, yes.
That's the way I read it. So we could probably get it in the afternoon. So it'll be either noon or 2 o'clock that will deal with that matter in Suffolk on, we'll call that 123 for now.
And I think, Your Honor, if I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's motion to dismiss the case.
That seems to be the right step to me as well. How does that sound to the parties?
Yes, we wanted to bifurcate the disqualification from that. Absolutely.
I think that's the right choice. Okay, so do we want to get that on the calendar now, or do we want to wait till the disqualification is done?
I think it makes sense to wait, but I'm at Your Honor's disposal.
We can wait because I'm pretty flexible when I schedule things in Suffolk. Okay, we'll wait on that issue. Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drafts without, as far as we can tell, respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks. We're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove, in his motion seeking an extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else. That would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control, and we haven't received that.
I don't know who you're talking about.
Jennifer McCabe.
Okay. Mr. Cosgrove?
I will look into that as to Mr. Betterow's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday. if the post office can be believed, does include materials that I received from Mr. Betterow, notably a grand jury exhibit that they recently complained that I'm sorry, received from Mr. Mello, not from Mr. Betterow. Notably a grand jury exhibit that the defense has complained that they had never received, that was not in my possession or in the possession of the state police. And I finally managed to get it from from Mr. Mello, who had that particular exhibit. So they'll be receiving that and some other materials from Mr. Mello.
Okay. All right. Well, if there are particular issues that need to be addressed by the court, let me know. We can get together quickly in the Zoom and deal with them.
Judge, I think there are, and respectfully to Mr. Cosgrove, Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything, so we don't have to rely upon Mr. Mello to discover grand jury exhibits from 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I'm going to leave the details of how Attorney Cosgrove complies with the Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible. Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradle, Mr. Bedroff?
It's a little premature for us, Judge. We're sort of baking the cake right now, and we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things because they are all the same folks, and it seems like this case, in terms of evidentiary, the acts themselves, I don't want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
it's a very fair characterization, Your Honor. There's a bit more to do on the newer indictment. We don't have grand jury minutes even yet, and
no, I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Kearney?
It's Kearney, Your Honor.
Kearney, I apologize.
Okay.
So look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done. Now, how long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be, on behalf of the Commonwealth, a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we've got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
Sound about right, Mr. Bradel?
I think so, Your Honor.
When do you folks think would be a good time to try it? I'm not going to hold you to this. I just want to start sketching out in my mind when and how we're going to do this.
Judge, on the 2-week thing, are you saying full days or half days?
I'll go full days.
Okay, that'd be fair.
Any thoughts on when we could do it? The only time let me just block this out. I'm supposed to do an asbestos trial in June. That's going to take just about a month. So June is going to be out completely for me. So, work in terms of our calendars, just sort of scratch that one off.
Judge, it's a tough call in light of how much stuff we still have to do. It's a tough call. I mean, I could see this not going until the fall, mid-fall. There's just so many. This team stuff takes forever. We haven't even gotten any automatic discovery on the second case yet. We're still waiting for a grand jury minutes. There's a lot of extraordinary motion practice here. Disqualification, dismissal for extraordinary government misconduct. Discovery, as my brother said, is dribs and drabs. We have this prosecutor who's very ill, apparently, who's no longer on the case. He's been disqualified. Attorney Cosgrove's been disqualified from the 24 indictments, which have now been dismissed. There's just so much going on in this case. It's not your garden variety situation. And I think we really are realistically, if you want to put a cap on it, I think the cap has to be, mid to late fall, because we're just not going to get all this stuff done. It's been historically glacial pace.
Just wait till I got you. And I don't have a problem with that. Mr. Cosgrove, how does that fit with your timeline and your availability?
Well, my availability is pretty open. As far as timeline goes, I don't associate myself with all of Mr. Bradel's comments. I agree with his bottom line. This is a complicated case in some respects with quite a bit yet to do and a lot of contingencies. And obviously, if Your Honor allows the motion to disqualify me, it won't be my problem, but that will certainly have an effect on the timing of any trial as well. I will say,
let me just slow you down for 1 second. The disqualification, as I can tell, is only on the 23 case. Is that accurate?
it is accurate, Your Honor, but if you disqualify me in the 23 case, it wouldn't make any sense as far as I'm concerned for me to try the one incident on the 25 case. I would respectfully ask the district attorney to relieve me of that responsibility.
Well, let's not go there yet. Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November? Maybe November 9th, 16th, December 7th.
I can do
Any
all
of those?
I can pretty much make those dates work, and I've checked with Suffolk, but we have flexibility here. Okay, so if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have
Sure.
access to that docket right now, but pencil yourself in for around that time. And we'll
Okay.
pick this up once we get through the motion to disqualify, which will be on the 23rd. Okay? So, but let's try to work our way towards that date, and get this thing in front of a jury and get it resolved one way or the other. Okay? What else can
Sounds
we
good,
do?
Your Honor. Thank you. I think that's everything on your agenda, Your Honor. I was following along on your scheduling order.
Mr. Cosgrove, anything else?
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to be paper copies. I'm not sure why he entered that order, but I do find sometimes that when we are close to a deadline, I am close to a deadline, that taking a special run over to Norfolk Superior Court to deliver a paper copy is a lot less convenient than being able to do it electronically.
I would read Judge Doolin's order to be a paper copy has to be filed. If you're up against a deadline and you have to email it in so we have it to prepare, that's fine, but a paper copy is going to have to be put in the file at some point. Look,
That's fine.
if there's a deadline set,
If that's Your Honor's interpretation, I can certainly
as long as
comply with that.
Attorney Bradley and Attorney Betterow and I have it,
That'd be a big help. I agree with it, Your Honor. Thank you.
But make sure a paper copy gets filed so that I'm not even sure that, Mr. Bradley, you can correct me because it's been a while since I sat in a criminal session in Suffolk. I don't think the Suffolk Clerk's Office takes electronic filings, do they?
No, they don't, Your Honor. Norfolk does, Suffolk doesn't.
All right. So right now this is a Norfolk docket. So you're going to continue to file there, but if you file electronically to the parties circulating the documents that way, that's fine.
Appreciate it. Thank you.
If it's a day late, it's a day late. You don't need to drive to Norfolk to get the paper filed that day. As long as it's electronically filed, followed by a paper file, that's fine.
Thank you, Your Honor.
All right. Anything else we can do today?
Not for the Commonwealth. Thank you very much, Your Honor, for your time.
So let me ask you one more question before we go. Are all the papers that I need for the disqualification motion filed?
No, Your Honor. Just a couple of hours ago, Mr. Cosgrove, I think, filed a response that, frankly, we had anticipated earlier, but we filed something addressing that yesterday, which I don't know if the court has seen or not. And Mr. Cosgrove filed something today. We've perused it. I believe I'm going to want to file just a brief reply in the next 10 days or so.
Brief reply. We have lots of
I'll do my best.
Lots of paper already in this.
I may have an additional filing as well, but it'll be well within the 10 days that Mr. Betterow speaks of.
I know that the civil rules have already been brought into play here in the pleadings here, that they don't apply, but there is that motion reply, sir reply, and that's it. You can file what you need to file, but
Yes.
it just doesn't. It's got to end at some point. All right. So file what you need to file. I want everything filed 10 days prior to the hearing. Okay. So no filings will be accepted on the disqualification issue unless there's new evidence after 1:13. Let's get this thing squared up and ready to be decided that day, or argued that day, decided shortly thereafter.
Yes.
All right. Anything else we can do?
Good, Your Honor. Thank you.
All right. I'll as soon as I get to Suffolk and I have a better idea where we're going to sit, I will give you folks notice as to the time and as to the actual time of the hearing and the courtroom in which we'll be. That'll be an in-person hearing.
Thank you, Your Honor.
Thank you.
Mr. Betterow, do you intend to be there in person?
I will. Yes.
Excellent. Because Zoom is a little difficult when some people are hybrids are difficult. Let's put it
Yes.
that way. Okay. That's all we have today. Thank you very much. Margaret, you can close it up.
Thank you.
Thank you, Your Honor.
Thank you.
As expected, a can kicking, but at the same time, a few notes I made. Better you absolute G, zooming into court, and we could tell that you were watching Columbo in the background. Baker approves. Cosgrove zooming in with a camera angle that showed that he was living in squalor with a blue bedsheet halfway in the background. Cosy G, get your wife out of the basement and fix that. He looked like a hoarder. And all the drip of Rule 14, all the late filings, everything has to do with Mr. Mello. The police have no evidence. The Commonwealth has no evidence. Every piece of evidence apparently resides in a box in Mr. Mello's house. No one can get to that box. That box is sacred. So how could they know that there might have been someone talking at a grand jury? Because it's only one of their main witnesses, Jen McCabe. It's not like, come on now. You can't believe that anyone other than Mello knew Jen McCabe, the main witness in the case, had said anything at a grand jury. We are, 2 years into the trial, and whoopty, Jen McCabe's grand jury minutes, her evidence that she has been harassed and stalked and her family has been harassed, hasn't been turned over fully yet to the defense. Slap me on my butt and call me a pelican. It makes no sense. It makes no sense that no one has that evidence other than the magic box at Mello's house. The second Mello couldn't do couldn't go on with the case, why the hell didn't they just get everything from his house? We talked about this at not the last hearing, but the previous hearing, that he couldn't contact him and they didn't have all the stuff. This is borderline insane what we're watching. And I know nothing will happen because it's Massachusetts and we don't give a F about anything. The motion to dismiss, which, as I interpreted the tone on the judge, won't happen. But that'll be argued in January 23rd, I believe he said. So that'll be a late birthday gift for me. I'm turning 27 in January. And Cosgrove wants to join the 22 and the 23 case. The defense said we need to talk more about it. And then a thing, and I'm not a lawyer, so I might have misunderstood or no understanding at all about what was going on. Cosgrove wants to put a lot of prior bad acts on display in the case. How many previous convictions has Aidan Kearney had? I have never really heard Aidan has been convicted of anything other than being too liberal with his dominator. How can you introduce prior bad acts if he has no previous? Has he been convicted of witness intimidation in the past? There's 0 charges that has ever stuck against him so far. So what prior bad acts can you just pull shit out of the hat and say, well, he was really mean in 5th grade. He went to school with 2 black guys because the school had called his mom and said he had black eyes. I don't get that reference either. I really don't understand what the hell prior bad acts he wants to put in there. It's going to be insane, the arguments. Well, this person, Krusty Panties, has said this about him. There are no convictions. If there's no convictions, how can you put it in there? Did Jemima say something? Or prior bad acts aren't limited to criminal charges, if I remember correctly. But what prior bad acts can you then what can you bring up? That he stole a stick of gum in 7th grade, and you can I'm conflubulated. You can just put everything in there, that he didn't hold the door at Walmart for an old lady. Cosgrove is gonna try to get everything in there. He's gonna put Kate Peters on the stand, and she's gonna testify that Aidan once threw trash out the window or something like that. It's prior bad acts only applies if there are convictions. 0 convictions means 0 bad acts. Once again, Cosgrove knows nothing about this case. Bad mouth, maybe the kid is right that you can have other things, but we'll have to look that up if that's possible, because send you the rule: likely past articles or videos that show he's aggressive or causes people to lose their job. Oh, let's do this. We can take a gander and see what it is he's gonna put up there. Gonna do this, gonna do that. Permitted use. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of incident. However, evidence of other bad acts is inadmissible where its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. Evidence of such an act is not admissible in any criminal case against the defendant who was prosecuted for that act and acquitted. Evidence of a crime, wrong, or other acts is not admissible to prove a person's character in order to show that on a particular occasion that person acted in accordance with the character. So yes, they can't bring it in if it's not overly prejudicial, right? Is what I'm reading. But there is no, him being an asshole online. I'm sorry, we are. It's part of being a YouTuber. We will say off the cuff things. We will talk a little tough guy sometimes. I'm just. This is going to be a shit show. You all know that, right? Yeah, and imagine Cossie arguing that, well, according to Kate Peter, on a show in 2017, Aidan Kearney said, "Fuck that cunt." In a show in 2019, Aidan Kearney said, "Fuck that cunt" twice. In a show in 2020, Aidan Kearney said, "She's a cunt." He has multiple times said, "Jen McCabe is a cunt." So we have to bring that in, Your Honor. It's imperative to show his intent to intimidate a witness. I'm sorry, Massachusetts. I really want to come to the next Wilbur, but I don't want to meet any of your ladies because they are apparently all absolutely insane. I don't want to meet any law enforcement officer because they are apparently all absolutely insane. I never want to enter a courthouse because you will get a conviction for some BS. So I might just go over there, sit in the airport, and look down over Boston, and that'll be my trip to Massachusetts. The phone stuff. We need the taint team to go over it, and the taint team has been going over it, but the taint team is still going over it, and the taint team need to go over it, and we need it not for this case, but for a different case, and we need his phone. We can't return his phone, even though we have the phone dump. So why can't you just give him the phone back? Well, we need it for another case, but you have it already. I don't know. Let's just go back and say, I don't know. It's the same with Karen Reed's phones. I'm beginning to think because Celebrite and those programs get better and better and better. I've seen how we in the beginning could get Facebook Messenger, but we couldn't get WhatsApp messages in court. Then we got to the part where we could get parts of WhatsApp messages. I believe Instagram is still, the last time I saw Instagram, no, Snapchat. Snapchat is still spotted if they can download it. I'm betting they are holding on to these phones so they can get Cellbrite when they finally crack Signal, because Signal is so far unbroken. That's why you should, if you are doing any of your side business, sliding into DMs or all of that, do it on Signal. So that's a little more secure than the other places. I've heard. I don't know anything about that one. If Baker goes to Boston, we need to be his bumper posse. Nobody gets to BB except through us. I'm afraid to go there. Better Row said, we can't work with this. It's drip, drip, drip all the time with Rule 14. We need our evidence to prepare for a trial. It won't happen till maybe late October, early November. Cossie had a big old problem to end with, because there is a rule that everything must be filed in paper form. So he had a big, because when timelines or deadlines were coming up, he had a big problem to file them, because he had to go to the courthouse and file them. And that was a big problem. Cossie, I love it when you call into the Clara show. I love it when you call into Aidan's presentations. But you're an idiot. You are an absolute idiot. You have not met any deadlines so far. So bringing up that you have a problem because you have to make a paper copy, this is the same thing I say every time people say, well, if we're going to meet up at 8, that means we're meeting at 8:30. No. You're disrespecting everyone by being late. So you will be there at 9:50, at 19:50, not at 7:50. That's what I'm trying to say. It's because 19 is 7 in real world numbers that Americans don't use. You will be there 10 minutes before to show that it's that important that you will be there waiting for the people you meet, who will always be there 10 minutes before. So if you get there in good time at the restaurant, you don't have to wait. That's just the Scandinavian way. Cossie, you cannot, under any circumstance, complain over deadlines, because you don't give a fuck about deadlines. You are an absolute asshat when it comes to deadlines. And then you're sitting there and blaming the paper filing. You filed papers 2 hours before trial today. I was reading them. And can I just recommend this judge, because he was absolutely spot on time. So they changed location. Is that right? That's because the judge has to go to another courthouse. He's going to have a seat in another courthouse, and that's where they're going to take it from there. I will come to the Wilbur 2 show, Baker, and you will love it. Give me a date, because those plane tickets ain't getting cheaper, is all I'm saying. Polls are the same, Baker, but Irish are always late. Well, disrespectful people. A YouTuber from UK was sent back because Logan Airport, Boston, checks cell phones from out-of-the-country travelers and didn't like the connections other YouTubers on his phone. I haven't had my phone checked, but I've been asked if I had Instagram. I've been asked if I had Twit, and yeah. And I asked him, "You want to see it?" He says, "No, I've been fingerprinted every time I get my face scanned. I apply to go to America. I actually have, if I need to go check, we have what's called an ESTA. I have to check. It's I can't remember if it's a 3 or 5 year visa. I love everyone is, oh my God, it's gotten so bad at airports. In 1995, when I was in Illinois, I had to write a piece of paper and sign it that I didn't go to America to do crimes. It's always been like that. So no worries. If he had bad connections, they must have been real bad, and he must have been on a list to begin with. He only has 2 cases and 1 investigation, but he can't meet deadlines. Meanwhile, the BS has the Bradles and Betterow and Bradles have multiple cases. Yeah, and he has murder cases coming up. He has Kelsey Fitzsimmons that's going to Superior Court. He can do his job. Cussy can't even clean his fucking room and put up a blue screen. How Jewels, bad acts for the Scanlon wiretap. They forgot to ask the grand jury to indict. I'll parlay that. But can they bring it up if they didn't charge it? Then it's just allegations. And again, every time you hear me cutting out and out, in and out, and everything is glitching, it's on your end. So if you're on a PC, hit F5, restart the window, or go up in the top and hit the refresh the window. It also makes YouTube think that I got a new viewer. So please do it, all of you, at once, because then I get more views. So yeah, this is like I'm saying to all the OnlyFans women: if you are gonna do the naughty pictures, first of all, clean your mirror. Don't have toothpaste spatter all over them. Clean your background, Lindsay Gattani. Don't have that rat nest of wires in the background. I'm so old that I will notice the background after I've noticed whatever. I don't know if I will. I've never gotten any of those types of pictures, but I believe I will, because he really annoyed me. Well, if it's a female, it might be. Nothing, as always. They won't be able to bring up prior. Well, we read the motion. They are, if it's not too prejudiced, if it is in the scope of it, but they will have to argue it at a motion. Why did Aidan burn it all down before his cases were done? Don't understand the question. Yeah, I want to clean again, 13 seconds and I'm ready to clean. No, go back and watch the last 10 minutes. You'll get a recap. The kid says they can use the prior bad acts if it's regular acts and not criminal cases. My guess is it's using it for motive and pattern of behavior exceptions. But again, all of the bullshit they're going to try and pull in there will be weighed as more prejudicial. I don't believe that. I just mean the videos on Karen Reed. The Karen Reed videos has nothing to do with these cases, and the videos from Karen Reed is a response to Karen Reed's minions starting the attacks on Aidan. I know a lot of people forget that part, the koalas and the kiwis and the kangaroos, then the pylon from the 39,000 feet and the Street Fighter. We forget all of that. It's Aidan who's the bad boy. Aidan didn't burn anything down. Someone was sent to town to burn Aidan down. And anyone who says differently are lying or willfully closing their eyes. Just go watch who didn't cover today's hearing. I'm just saying. Has nothing to do with anything else. Karen Reed can't do anything. Don't question Aidan about the cell phone. Question who gave it to the Aussies, because that wasn't Aidan. Question who recorded other conversations. Stop putting this on Aidan. It wasn't him who started all of this bullshit. And a man can only take so much before he is allowed to retort. Funny how, Aidan is such an idiot. What about all the other guys? What about the people who piled on? Well, but Aidan is a misogynist. You know that? Aidan is mean to women. He calls them cunts. He's really a bad guy. I don't want to get sweaty over that. I don't want to get heated over that. So I'm going to leave that alone and just take it as an attempt to troll. And then I'm going to read the rest of this, and I'm going to read Bettero's response, and then I'm going to go to bed because I'm driving to see Baby Baker tomorrow. And that's better than anything I have been doing today. That's what I'm saying. So I hope the trolling got out of the system. And thank you all if you're leaving, because I will be doing reading the rest of this, reading Bettero's response. Thank you all. Please do all the YouTube things on your way out. Come back to another presentation. We started yesterday trying to do Spaces presentation as call-ins. It won't be every day, but I would like to do it at some other points. Yes. Back to reading all of this. The defendant's third and final request is the most blatant. He asked the court to disqualify Cossey from an ongoing investigation of Karen Reed and Mr. Kearney for conspiracy to commit witness intimidation, the 2005 investigation. Again, based on the alleged irreconcilable conflict, I can't say that word, with Ms. Kearney, to facilitate his demand to this court preemptively intrude on the lawful authority of the executive branch, Kearney attempts to mount an attack on a search warrant authorizing seizure of cell phones belonging to Karen Reed. As this court undoubtedly knows, when there is a claim that seized electronic devices may contain attorney-client privileged material, a taint team is generally required. Moreover, 2 search warrants are required, though the 2 may effectively be combined into one. So the process is search warrant 1, authorizing seizure of the device. Taint team established. Search warrant 2, limiting the scope of the search. Presently, the matter of the Karen Reed search warrants, and establishment of a taint team is before the court. Krupp, having heard argument, received memoranda, and taken the matter under advisement. It is part of the normal search warrant process. Assuming the court allows the Commonwealth's motion to set up a taint team procedure, and assuming search warrant number 2 is authorized by the court, and assuming a resultant search yields evidence, and assuming that evidence results in a grand jury presentation, and assuming the grand jury then indicts Karen Reed, then Karen Reed, as in any other case, may bring a motion to suppress that evidence. Assuming all of this is 2 years worth of crapiola. This should be thrown out. It has no bearing. They tried once, and there's nothing new. It's the same data they are trying to manipulate to get a grand jury. This should be tossed. Karen Reed may bring such a motion, not Kearney, who has no standing as he lacks any processory or other cognizable legal interest in Karen Reed's phones. Attorney Bradel attended the hearing before Judge Krupp, having been notified of it by the clerk on information and believed that this was because former counsel for Ms. Reed had for some reason filed a motion for return of her cell phone under the caption Commonwealth v. Kearney, albeit based on the evidence of the certificate of service, he never served Kearney with it, only the Commonwealth. On the basis of that caption, the clerk assumed that Mr. Bradel should be notified. At the hearing, Mr. Bradel promptly announced that Kearney took no position on the motion before the court, which saved the Commonwealth from having to point out his total lack of standing, at least until now. Conclusion: for the reasons set forth here, the Commonwealth asks that this court deny the defendant's motions. So that is roughly what we also heard in court from him. And that was a 10-piece memorandum, and we have a little bit more from Mark Betterow and Timothy Bradel, filed yesterday. Whew, this is going to be a long night. I'm not. What? Who's what? The Commonwealth's untimely response. The defense motion to dismiss was filed on September 17th. The motion to disqualify Robert Cosgrove was filed on October 3rd. The prosecution was first directed to file its response by Monday, October 27th. On Friday, October 24th, after the clerk's office was closed, the Commonwealth emailed the defense a copy of a motion seeking an extension. Unknown to the defense, the court had already granted the motion and directed the Commonwealth to file its response by November 17th. The Commonwealth ignored this deadline and served the defense on Tuesday, November 25th, which essentially was the day before Thanksgiving. The response was accompanied by a motion seeking an extension, which was tantamount to the Commonwealth seeking forgiveness rather than permission. That's a good way to say it. Is more noteworthy for what it fails to include rather than for what it does. The purpose of this reply memorandum is to clarify big picture issues for the court in advance of oral argument. Giggity. Strikingly, Mr. Cosgrove ignored the elephant in the room. He and lead investigator Tully have been sued by witness Lindsay Gattani for intentionally harming her during their prosecution of Aidan Kearney. Without more, the court should refuse to consider Mr. Cosgrove's submission unless the court concludes that he shouldn't be disqualified due to his conflict of interest. The defense detailed how former Special Prosecutor Mello impaired the integrity of the grand jury proceedings. One expects that the Commonwealth would oppose serious allegations of pervasive prosecutorial misconduct by including, with its response, a detailed sworn statement from Mr. Mello. Yet rather than submit any sworn explanation from him, the Commonwealth provided woefully inadequate unsworn hearsay from Mr. Cosgrove designed to justify Mr. Mello's misconduct. Acutely aware that Mr. Mello's too many to count errors before the grand jury impairs its integrity, the Commonwealth mostly ignored addressing his misconduct or case law supporting the defense. Instead, it urges the court to avert its eyes from the flawed grand jury proceedings by concluding that the defense waived this argument. As detailed below, the Commonwealth's preference for form over substance sought to mislead the court by ignoring binding precedent contrary to its position and by relying upon inapplicable civil practice rules. Argument point 1. The court should not consider the Commonwealth's response unless it determines that Mr. Cosgrove should not be disqualified. The irony of Ms. Cosgrove's snarky criticism of the defense motion should not be lost on the court, given his failure to address the blatant conflict resulting from his prosecution of a matter in which Ms. Kearney is both his accuser and a witness, and where her credibility will conflict with that of his co-defendant, Tully. On October 8th, in a related hearing regarding his ongoing effort to search Kearney's cell phone, Mr. Cosgrove acknowledged the problem of whether it was appropriate for him to respond to the disqualification motion. If Mr. Cosgrove realized that it was improper for him to respond to that motion, he must also recognize the same problem exists with the Commonwealth's response to the motion to dismiss. Although Mr. Cosgrove avoided directly confronting his conflict, he unwittingly illustrated why he must be disqualified. He believes that Ms. Kearney is a witness who possesses information that is favorable to the case he is prosecuting against Mr. Kearney. As Mr. Cosgrove wrote, discovery provided by the Commonwealth shows that Kearney was indeed a witness, interviewed by the Popo with specific attention to what she knew about Kearney's ongoing communication with Karen Reed. After that interview, she received a summons to testify before the grand jury. It is hard to fathom a conflict worse than one where a prosecutor civil defendant concedes that a witness plaintiff suing him possesses information helpful to the prosecution. It is worse. Ms. Kearney wasn't simply interviewed by the police. She was an important witness against Mr. Kearney, who was debriefed about the subject matter of the instant indictments by Tully, who just happened to be Mr. Cosgrove's co-defendant in Ms. Kearney's lawsuit. Lest there be any doubt that Ms. Kearney was an important prosecution witness, Tully relied heavily on her information to establish probable cause to obtain a warrant to seize Ms. Reed's cell phone, which years later Mr. Cosgrove seeks to search. Mr. Miller instructed Tully to serve Ms. Kearney with a grand jury summons, the purpose and timing of which has led to the defense to argue that the investigation of Mr. Kearney was conducted in bad faith. In his overly sarcastic eagerness to ridicule this theory, I like Betterow. Mr. Cosgrove unintentionally confirmed his conflict by emphatically agreeing that Ms. Kearney is a relevant witness in regard to this matter. Mr. Cosgrove similarly ignored the significance of his accuser's allegation against his co-defendant. While flippantly mocking the defense conspiracy argument, Mr. Cosgrove highlighted the intertwined conflicts arising from Ms. Kearney and D.A. Tully's dispute regarding whether any content was deleted from her phone before an extraction report was provided to the defense. Ms. Kearney has repeatedly accused Tully of deleting evidence from her phone. Tully denies this. Cosgrove has effectively accused Kearney of lying by supporting Tully's claim. Tully's claim that any missing data on the extraction report was removed from Ms. Kearney's phone before it took custody of it. The conflict is further exacerbated by Mr. Cosgrove's support for Tully's position about his communication with Ms. Kearney and the content of her phone, and his assertion that cell phone expert Tully couldn't access his text communication with Ms. Kearney from his iPhone. All of these examples establish that Cosgrove's conflict is suffocating. In addition to endorsing Tully and effectively discrediting Ms. Kearney, he has made himself a witness in the inevitable sworn dispute from the witness stand between Tully and Ms. Kearney over the content of her cell phone. While it is admirable that Mr. Cosgrove desires to prosecute this contentious matter, he cannot close his eyes and wish away an obvious conflict where the interests of a witness who should be favorable to the Commonwealth are directly adverse to his personal interest, as well as those of the lead detective. For those reasons and those described in prior defense submissions, Mr. Cosgrove must be disqualified from this case, and the court should reject the Commonwealth's November 25th, 2025 filing. On September 22nd, Mr. Cosgrove moved to withdraw from now dismissed docket number 2482 because of his conflict with Ms. Kearney. He reasoned that he was ethically precluded from prosecuting matters where Lindsay Kearney is an alleged victim or party. October 2nd, any perception that Mr. Cosgrove's conflict was created solely because Ms. Kearney was an alleged victim or party, as opposed to merely a witness, is a distinction without a difference. I like his writing style. Point 2. The defense has not waived its right to argue that the Commonwealth impaired the integrity of the grand jury's proceeding. To the extent that the court entertains the Commonwealth's response before addressing Mr. Cosgrove's conflict, it should summarily reject the Commonwealth's crafty argument that the defense has waived its right to argue for dismissal on the basis that the integrity of the grand jury proceedings was impaired. According to the Commonwealth, the defense has not satisfied all of the prerequisites of Superior Court Rule 9D before seeking dismissal, stop it, Baker, of the indictments after a prior dismissal motion was granted in part and denied in part. Commonwealth's opposition, page 6. The Commonwealth's emphasis that the defense has flouted all of the prerequisite implies that Rule 9D is binding on the court. This is profoundly misleading. The rule applies to civil cases, styled applicable to all cases. All civil motions shall be governed, where applicable, by Superior Court Rule 9A through E. Superior Court Rule 9D styled applicable to all civil cases. In any event, it is well established that the court may consider the pending defense application even if it concludes that the pending motion includes grounds which could have been raised in a prior filing. Commonwealth v. Haskell. Reconsideration of prior motion is not restricted to situations where the defense could not have known additional grounds prior to the first motion. A court's power to reconsider a prior decision during the pendency of the case is firmly rooted in the common law, irrespective of Rule 13 of the Massachusetts Rule of Criminal Procedure. Commonwealth v. Cronk, Commonwealth v. Pagan. If the court does accept the Commonwealth response, the prosecution, of course, may advance any good faith waiver argument. The Commonwealth ignores the fact that the defense also has moved for dismissal of the indictments on the basis that the prosecution has engaged in egregious, deliberate, and intentional misconduct, the cumulative impact of which includes misconduct before the grand jury. But the Commonwealth is not entitled to mislead the court on the applicable law. Candor towards the tribunal. Point 3. The court should reject the portion of the Cosgrove affidavit containing hearsay from Mr. Mello. Mr. Mello was assigned to this matter for more than 2 years. Despite the defense frequently raising the issue of Mr. Mello's conflicts on 2 matters, he has been disqualified from the 2024 indictments. The Commonwealth only consented to Mr. Mello's disqualification from the instant matter on November 25, 2025. Mr. Mello is entitled to sympathy due to personal challenges he has faced for more than 1 year. However, during that period, he has attended virtual court proceedings, communicating at length with Mr. Cosgrove, and been active on social media. Respectfully, Mr. Mello is communicative and capable of using a computer. Nevertheless, we are to believe that Mr. Mello is not electronically sophisticated. Tully Affidavit, November 23. To the extent that he cannot format a Word document, Mr. Mello's formatting problem apparently thwarted him through no fault of his own from returning an affidavit Mr. Cosgrove prepared and emailed to him. Cosgrove Affidavit. Mr. Mello's formatting conundrum served as the Commonwealth's proffered excuse for failing to submit a sworn statement from him in response to detailed allegation of his pervasive misconduct. Thus, the Commonwealth apparently had no choice other than to file hearsay from Mr. Mello in Mr. Cosgrove's affidavit, which amounts to nothing more than Mr. Cosgrove cosplaying, good one, as Mr. Mello in different font and typeface. All of this is absurd. Mr. Cosgrove was a prosector for 20 years, after which he served as a Superior Court Justice for 14 years. Mr. Cosgrove's impressive credential led Norfolk District Attorney Michael Morrissey to personally ask him to help Mr. Mello with legal analysis and motion work. Mr. Cosgrove has extensive government resources available to him, including the authority to utilize police officers as he sees fit. In these circumstances, it strains credulity that an experienced prosector was unable to secure a sworn statement from Mr. Mello on critical issues that only he could answer. Mr. Cosgrove could have prepared an affidavit for Mr. Mello, inserted the revisions suggested by Mr. Mello, and had someone bring the document to Mr. Mello for him to review and sign. Mr. Cosgrove could have had an employee from the DA's office help Mr. Mello format his Word document. Instead, Mr. Cosgrove apparently waited as Mr. Mello struggled to format a Word document before he simply gave up and himself swore that Mr. Mello purportedly told him. Virtually all of the alleged misconduct cited by the defense was attributed to Mr. Mello. Mr. Cosgrove's decision to engage in lengthy one-on-one conversations with Mr. Mello before he adopted his voice and swore to what Mr. Mello told him conveniently shielded Mr. Mello from being placed under oath while still affording the Commonwealth to explain his actions through Mr. Cosgrove without legal consequences. This is inappropriate. The court should reject all statements attributed to Mr. Mello in Mr. Cosgrove's affidavit. Moreover, the bizarre manner in which Mr. Mello's statement has been presented makes Mr. Cosgrove a witness at any hearing on the defense motions regarding numerous issues, including conversations between Messrs. What? Messrs? I don't know what that is. Cosgrove and Mello about the latter's proposed revisions and his inability to execute an affidavit. Such a scenario will create another problem for the Commonwealth, since Mr. Cosgrove is the last man standing on the Kearney prosecution team. Accordingly, the court should strike paragraphs 26-58 from the Cosgrove affidavit. Conclusions. For the foregoing reason and those stated in the prior defense submissions, the court should determine the defense motion to disqualify Robert Cosgrove before considering the Commonwealth memorandum in opposition and grant the previously requested relief. Mark Bitterow and Team Bredel. Messers are misters in plural. Thank you for letting me know. Lindsay Kearney may soon go live with Melanie. Interesting. Is that something that is announced, or is it that someone believes that? Whoops, that was the wrong one. That you believe that they might set up a date. Is there a stream up for it? Because then I would chuck people over there. Cosgrove doesn't want to submit anything on paper, and Mello can't submit anything electronically. How much are taxpayer paying these folks? Well, if they're going by the same rates as Brennan, it'll be probably millions before we're done. You can't just say, trust me, bro. Well, you can, but the court doesn't have to. Well, the court shouldn't accept it. That's what it is. I read that as live and in live with Melanie for some reason. It's interesting if she's going to go on, and I said that before Lindsay blocked me and called me fat and said I looked like I had Down syndrome. No, I don't think that was her. But she said I was a misogynist, which you all know. I hate you women. But if they have a stream set up, I would redirect to that, because I don't know. I would trust Melanie to steer her. There's a famous Ricada clip from a guy who made a comic book company and got into some charity, and Ricada, even though at that point he was kind of on his bad behavior tour, he said, you really need to stop talking now. You need to stop talking, and this guy was just, I don't give a shit. And I hope Melanie, because Lindsay will be paramount to this case. So I hope Melanie. I trust Melanie. I don't trust Lindsay. I trust Melanie. Don't anyone believe I don't. I don't think she would set her up to say something stupid, but I don't trust her enough that she won't say something stupid. Kirk is trying to insinuate that LG has jumped ship because of intimidation, not the fact she was intimidated by Tully, KP, and Jen McCabe. Exactly. And then he intimidates her again and says if she changes her story, she will be getting perjury charges. Isn't she just popping off in chat? I don't know. That's why I'm asking if there is a stream set up, because I think people should. I think people should go look at it, because she might say something very, very interesting, and you never know. It could be just a wet fart, and it could be great to look at. I would probably give it a looks. Thank you. Melanie is an attorney. She'll steer it right. Yeah, but the problem is you can't save idiots from their own mouth. We see that in court all the time. And I'm just saying, even though Ricada didn't want to get this person in problems, because some of the things he said about giving things to charity came off as not that well. Just say IRS probably got really interested. Monsieur Ray from Dallas, congratulations on your absolutely long ass stream again this morning. You outstream me, mister. Who are we talking about? Eric July. Are you schizo, Glenn? You have never heard Lindsay speak? Lindsay, she has some very horrible videos that she put on her Substack and also on other media. I'm not her biggest fan, let's just say that, but I've also said that because she is helping the defense now, I'll hold my my critiques to myself. So yeah. Linz is only in Melanie's chat pointing out how Costco and Tully lied about the police. Okay. I thought that but if she goes on, that could be interesting. I'm part of the cool class. No, I'm part of the weird foreigners who apparently meddle in America without being allowed to do that. Schizo Glenn was your nickname in college. Did one of your other personalities give it to you? Yeah, loose lips sink ships. No, you're not going to make an inappropriate joke about that one as well. But yeah, that's the big old problem that these people will talk to. What do I say every time we watch a trial and someone takes the stand? Your mouth will put you in prison more than the police will. Did the muffins come out okay? The blueberries made it all look a bit weird before baking. Give me 2 seconds. And I was muted. I'm saying putting them in paper was a bad idea because they will stick to it, but you can They taste fine. They're soft. She can throw them out if she doesn't want them. Maybe I would have added a little bit of salt, but can't do that to kids. Those are muffins for 2-year-olds. It's a muffin for a 1-year-old. It's a 6-month-old recipe. That's where it's from. Thank you, Jemima. But are they as good as your pineapple upside down cake? Who was it who gave me that book? Was it you? I think it was you who sent me that book. That book should be burned on the stake. They look good. They taste fine. They're not. I wouldn't use it for an adult because there's no salt in it, so it kind of blends out the flavor. You should go. No, I didn't show that. I made some blueberry muffins as part of my old political party asked me to do something for the election we just went through, and I baked them 100 blueberry muffins. So they're good. They're good. I have seen so many people lately talk about not having trust, never having relationships out of fear, and so on. I like that too. I'm like that too, but it's truly sad to see. Well, it's because I think you breed it into us by, oh, you can't trust anyone, and everyone are doing things behind your back. Again, as I've said, if I'm in a committed relationship and she wants to go through my phone, well, I'm not in a committed relationship anymore, because if she doesn't trust me, then she shouldn't be with me. And if I'm fooling around and having fun, then we're fooling around and having fun. It's the same I've said. If you want to cheat on me, just phone me. I'll make sure all your shit is packed when you come home the next morning. I won't be mad. It just means that our time is up. I don't want to go and check everyone behind their back. It's not my problem. And again, there's a difference if you're dating or a couple, or if you're having some fun. But all of it, you have to have your level of trust in it. And I think too many people are scared to commit. So it's easier to say, well, I would be hurt anyway. And it's true. You might you might get unlucky. You might also have a really, really great time with a great gal or girl, provided that both of you understand the playing field. And you have to be honest up front and say, this is where I see this going, or this is what we're doing. And if you can live with it, fine. If you can't, don't do it. But I think most people today preemptively say, well, it'll never work. All of it will be bad. I think that's where the problem is. Again, I'm a 27-year-old single virgin. What the fuck do I know about relationships? So yeah. But I think most people are afraid of the commitment to put in and invest some emotions. And again, we are all older. I'm not getting married again. I don't need that. I don't have any plans about that. That has cost me relationship. I don't want more kids. That cost me relationships. When I got divorced in my early 20s, I lost a lot of relationships because I didn't want to change my stance on that. But I had always said it up front. No more kids. I'm never getting married again. And then don't come 3 years later and said, but I thought. Because I'll tell you up front. Them's the rules. Well, if you can't be honest, you're not ready to commit. That's the problem. It's not that hard, and you can tell what your intentions are. And if the other part said, well, again, I don't know anything about modern dating or anything. If let's use Turtle Boy. We have heard a little bit about his trouble. If you slide into his DMs and say, "Hey, daddy," and he says, "Show me your titlets," and you say, "Okay," and he says, "I want to fool around, but it's going to be fooling around," then you shouldn't expect he's going to put a ring on it, and you shouldn't expect that no one else slides into his DMs because you did it. My buddy had a grandfather who said, "The way you win them is the way you lose them." So it's if she cheated on her boyfriend to get with you, she'll probably cheat on you to get with another boyfriend. Again, it's you people should relax a little bit, let loose, have some fun. It's a modern world. You can explore something on the internet, but also know that it's on the internet. Or you can try going to a bar and say, "Hey, just don't go to a guy who makes food, swipe, cleans his table with a broom, and puts way too much sodium in his food. Stay away from them. But go out, and again, if it's too much of, you can just say, "Oh, ooh, that's not what I want." You can always back away from it, but just put some ground rules and say, "These four walls are ours." Well, I don't know. Ray, you know me. I'm 27 years old. I've never been laid, and I'm single. What do I know? The gym is a good place, except if you're a fat old man, then you're a creep. So, yeah. Well, you can only try. And if you don't put your heart out there, you will never get loved, but sadly, it'll come home burned a couple of times. How did you have two daughters if you have never been laid? My wife told me you can have that. If you just love each other enough, you don't have to have intercourse. She said that's normal. What do I know? I'm a baker. I'm not a biologist. So yeah. And again, this is, you can do that, or you can have a online relationship. Again, I don't judge you as long as it's age appropriate, consenting adults. You have your fun, but don't go absolutely cray and start sharing DMs when it didn't land you that ring you really wanted, even though you were told you won't get it. And don't offer coke and MDMA to old guys. We have enough trouble. We don't need coke dick. I don't know what I'm saying. Well, I'm gonna jump off because I am driving to my daughter's tomorrow and looking at a house. And I hope you will have a wonderful Friday night. And again, be a little adventurous. Have a little fun. That's the cool thing about the internet. You can do things online that your mama probably would have said, "You can't do that," and just enjoy life without all of this worrying about, "Oh, will everyone think I'm okay?" And oh, we only have one life. It would be a really, really bad thing when you reach the end and you think, "I should have done it." Shoot your shot. You never know. Ray, are you going live later today? Yes. Yes, do that. I love that thing. Go buy something from a small business this weekend. If you want a coffee, walk past the Starbucks and go to a small cafe. If you need, I don't know, extension cords, instead of going to Costco, Go to that little electronic store that is struggling. You will miss the small stores when they're not there. The good service and all that. Yeah, but it's cheaper online. You don't want to save that $1. Go help someone out. Yes, sir. When are you going live later? I don't know if I'm gonna go YOLO, but again, I just think that I'm getting too old to do all of this. No, I'm gonna step away from it. If life give you lemons, don't make a cheesecake. That's just the rule. And life is beautiful. Life is fantastic. Have I been burned by life? Tons of time. Have I gone through a lot of shit? We all have. But I wouldn't change the thing because I wouldn't have been here with you if anything else had changed. That's what you should remember. Don't cry about the past. Because without the past, you wouldn't have been here. I will enjoy Baby Baker. Again, I'll probably sneak in a stream now over the weekend. Did we get a time from Mr. Ray from Dallas? I'm not sure if Ray from Dallas gave me a time. I missed it, but it's almost 10 o'clock and I have to drive tomorrow at 8. Go crazy. Do something fun. Just enjoy life. We need to enjoy life. Life has been putting us all down and watching another nothing burger. But life is beautiful. You have friends, you have a great chat, you have that guy, whenever he looks at you, you think, oh, I haven't felt like this since I was 14. And you have amazing YouTube creators that you can go and watch, and you have all of these support groups that you can be in the Discord with. There's no reason to cry and be mad. Just enjoy life and whatever it brings, as long as it's age appropriate and consensual.
I'm Jimmy. How y'all doing?
I know English is your second language, but you don't word
It's
your
my
questions
third, but
carefully.
I'm still better at it than you. You are
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the